Welcome to Ties That Bind, Law, Family, and Legacy.
Welcome back to Ties That Bind, Law, Family, and Legacy with Patti Garner. Patti is a Tennessee attorney who focuses on estate planning and probate, helping individuals and families make clear, thoughtful decisions about the future and avoid unnecessary complications down the road. With over 20 years of legal experience, she brings a straightforward, practical approach to these conversations. I'm Shameika Rhymes, and today we're talking about how probate works in Tennessee and what families should expect. Hey, Patti.
Hey, Shameika. How are you?
I'm great. How are you?
I'm good. So good to see you.
So good to see you. Well, let's talk about what is probate in Tennessee and in what situations does it actually come into play?
Ooh, probate in Tennessee is a hot mess, like any state. Probate is the process where we are administering an estate when someone has passed away. That's the primary use of the probate court. There's some other things that they do, but that's the primary use. So what that looks like is somebody has passed and we are probating a will, or we are administering, the stuff and trying to figure out where it goes and who gets the car and who gets the house and who gets the jewelry. There's also a side to where we have to notify the creditors. And because of the time frames and to have it open, have an estate open to allow the creditors time to get in and file, it has to be open at least 4 months. But that I have seen drag on. 2.5, 3 years, depending on, you know, how much stuff we were dealing with. So there's your probate process.
Wow. Does sound a little bit drawn out and messy.
It can be. It absolutely can be. It can be avoided with a proper estate plan to where you're not tied up for that long and you don't have the judge making decisions and doing all the things that come along with just a run of the mill will.
Mhm.
But I mean, if you don't have that, then the probate process is where it's at.
So once probate is required, what does that process actually look like from the very beginning?
So you have to file a petition to open a probate estate. You appear before the judge. You get an appointment either for an administration if there was no will, then you would have an appointment of an administrator. If there was a will, then you would have an executor or an executrix that's appointed, and that requires a court appearance. Typically, it would require a bond, particularly if there was no will. Then we have to notify all the creditors. We put everybody on notice that the person has passed, and we begin the notification, and then we wait. Now, sometimes in the mix, we have a house that has a mortgage. We need to sell the house. We have to go get judicial permission to sell the house, put it on the market. If there's an offer that comes in, you have to get permission from the court to sell the house. Um, to see if there's gonna be enough money to pay out bills. I mean, it's a process. It really can be, a lengthy process.
Did you say bonds? Like, you have to get a bond? What does that mean?
So it's a surety bond. So
Okay.
if you particularly if somebody has passed without a will, then the person who steps in to be the representative for the estate would be they would have to get a surety bond from an insurance company, basically saying, I have no criminal history and I'm going to do my duties and I'm going to be faithful and, not steal money, basically, is what you're promising to do. And so that's just another added expense that the estate would have to bear. And that's just part of the process.
Okay. Well, who's responsible for handling this probate and what does that role really involve behind the scenes?
Wow. So it really depends on whether or not there's a will.
Mhm.
If there's no will, then it would fall to the next of kin if they were interested in pursuing it. If there is a will, then it's designated in the will who should be the one to proffer the will to the court and get all those steps rolling.
And so if the person that's next of kin says, "Nope, I'm not doing it. I can't. It's too much." Um, have you had that happen?
I have seen that happen in an estate that I consulted on not too long ago. And they just were, time and distance. They were, nieces, and they lived too far away from where the actual person passed, and
Nice.
they just weren't willing. They were like, there's not really anything in the estate, and it's just not really worth it. So they did not pursue it to my knowledge.
Oh, okay. What types of assets typically go through probate and which ones are handled outside of it?
So life insurance with a beneficiary designation would be outside of probate. A 401k with a beneficiary designation would be outside of probate. Inside of probate would be a home, would be a car, bank accounts if they don't have a paid on death designation for a beneficiary. Your personal property. Don't We don't really think about it, but your chairs and your tables and all the things in the house. All of that makes up what has to go through probate.
I had no idea even furniture has to go through probate.
Furniture has to go through probate. Now, again, it's one of those things where the judge is probably going to say, look, this is not really not that it's not worth his time, but it's bogging down the court system to fight over a $25 table. Y'all, come on, sell it and put the money in a pile.
Right. Have a yard sale, mark it up.
Right. That's right.
Well, how long does probate usually take in Tennessee and what tends to affect that timeline?
So it is designated to be a 4-month period. So the minimum time that it can be open is 4 months. What creates a longer timeline is how many heirs, how many creditors, who fights and files and who wants their share, how many times we have to have court appearances, and then that delays other things. And it really depends. Each case is so specific, it's really difficult to give you this is what it typically takes. I tell people when we open an estate, it's supposed to take 4 months. It could be 4 months, it could be 2 years.
Mhm,
I'm hoping it's 4 months. But 4 months does not mean 4 months to the day. So on day, 120, don't call me for an order. But
mhm.
maybe by day 130, we'll have an order, just depending on the way the court dates fall and that kind of thing.
So once the, I guess, and I don't know if I'm using the right terminology, if the estate is closed or everything is handled, and say there's several heirs, are they all notified by the court or who handles that?
Sure, there would be a closing order that designates where all the stuff went. And then that will go out to all the heirs. Now, a lot of times, the heirs will come in and sign an affidavit, and that
Mhm.
gets filed with the court. And that affidavit says, "I got what I got, and I'm satisfied. Close it out." But that's one of the ways that we use to close out that estate.
Oh, okay. All right. Well, where do you see the probate process start to slow down or become more complicated? Because, some people they want to rush, but, like we spoke about in the last episode, sometimes there's mistakes being made, with the estate plan itself.
Right. Um, It bogs down really with creditors, it bogs down with heirs, and it just depends. It depends on how well written the estate plan was, how well written the will was, or what the designations were, or was the will updated, or did the will only provide for one child and not the second child that was born, 5 years later? There are just so many variables. That's a real hard question to answer.
Well, can you walk us through a situation that you've seen where probate didn't go as smoothly as the family expected?
Yeah, we have one right now where it's not going as smoothly as they expected. Um, we had a person who passed. We believed that he passed without a will,
Mhm.
and there was a girlfriend that showed up with a handwritten piece of something that's not signed, not notarized, not anything. And we've hit that 4-month period, and everybody's upset because we can't close this estate because we're having to talk about this piece of paper. Um, and it just goes back to not making sure that you named who you named, and that you crossed your I's and dotted your or dotted your I's and crossed your T's, um, just to make sure that everybody gets what you want them to have. I don't know if this girlfriend's legit. I don't know if he wanted her to have that, but there's this piece of paper. So
So do you bring
we're
in
gonna fight
somebody
about it.
that analyzes handwriting just to look at this?
I suspect that's where we're headed. But in Tennessee, you got to have a signed and a notarized will, and you can't transfer real estate. And
Mhm.
there's a whole lot of parameters to it that this particular piece of paper does not measure up to. So I'm gonna be curious to see how that one turns out.
Is it written in pencil? I don't know why in my head it's written in pencil.
No, but it is handwritten.
Well, um, what parts of the process tend to catch families off guard once they're in it? I suspect something like this for sure, but
Something like that for sure. If you've never been through the process, you don't know what to expect. So I tend to think that everything catches people off guard. We try to prepare our clients for this is your worst case scenario, this is your best case scenario. We try to do that real straightforward, real direct, but I can't plan for every scenario. Some things come out of the wild, wild west, like this piece of paper that's unsigned. I mean, it's just one of those things where you put it up to the court and you see what they say, and then we follow the direction of the judge.
well, how does having a well-structured estate plan change or simplify this probate process?
It can almost completely avoid the probate process if it's done well. So if you have moved, you set up your trust and your estate plan, and if you have moved all of your titled everythings into your trust, say your real estate, your vehicles, everything into your trust, then there's nothing really to probate. We have to file a claim for creditors and do that kind of thing. But there's nothing really to fight over there in probate court. It's just a matter of letting the time run, letting the creditors file and do what they say they're going to do. In the meantime, we're over here, we're operating the household, we're doing everything like we should have been doing or needed to be doing. We're paying house payments and paying bills because we have the authority under the trust to do that. The minute somebody has passed away, we're not having to wait on the judge to give us permission.
Well, thank you, Patty. This has been helpful as you've explained how probate works in Tennessee and the things that families should expect if it comes out of left field or in a handwritten letter. Thank you.
Thank you.
Well, that is it for today's episode of Ties That Bind Law, Family, and Legacy with Patti Garner. If you have questions about your own estate plan or you want to make sure you're making the right decisions for your family, you can reach out to Patti Garner at Garner Law Firm by visiting pattibgarner.com. Thanks for listening, and don't forget to like, leave a review, and share this episode with someone who might need it.
Y'all give me a call and let's plan your legacy.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.